the Property Rights of Spouses Act, 1st of April 2006, Part 1, Preliminary, short title. This act may be cited as the Property Rights of Spouses Act, Section 1. Section 2, Interpretation, subsection 1. In this act, cohabit means to live together in a conjugal relationship outside of marriage, and cohabitation shall be construed accordingly. Family home means the dwelling house that is wholly owned by either or both of the spouses and used habitually or from time to time by the spouses as the only or principal family residence, together with any land, building, or improvements appurtenant to such dwelling house, and used wholly or mainly for the purposes of the household, but shall not include such a dwelling house which is a gift to one spouse by a donor who intended that spouse alone to benefit. A gift from a donor. So if your parents, grandparents pass down a house to you with the understanding that it's yours and yours alone, that would not be considered by the court to be the family home. Marriage includes a void marriage referred to in paragraphs A, B, and C of section 4, subsection 1 of the Matrimonial Causes Act. Property means any real or personal property, any estate or interest in real or personal property, any money, any negotiable instrument, debt, or other chose in action, or any other right or interest, whether in possession or not, to which the spouses or either of them is entitled. Relevant child means a child who is A, a child of both spouses, or B, a child of one spouse who is accepted as one of the family by the other spouse. And in paragraphs A and B of this definition, child includes an adopted child and a child of a void marriage. Spouse includes a single woman who has cohabited with a single man as if she were in law his wife for a period of not less than 5 years. So that person is considered a spouse. They're cohabiting, not married, but the period of cohabitation is not less than 5 years. So B, so part A considered the woman who was cohabited with the single man. Now part B, a single man who has cohabited with a single woman as if he were in law her husband for a period of not less than 5 years. So that person is considered in this act to be a spouse. Now, immediately preceding the institution of proceedings under this act, or termination of cohabitation as the case may be. So, here, spouse include these persons immediately preceding the institution of proceedings under this act, or the termination of cohabitation. Subsection 2. The term single woman and single man used with reference to the definition of spouse include widow or widower, as the case may be, or a divorcee. So, your wife has died, your husband has died, you found somebody new, living with them for 5 years but not married, you are their spouse. You have been divorced and found somebody new, living with them for 5 years or more, you are that person's spouse under this act. Section 3. Application of act. Subsection 1. Except as otherwise provided in this act and subject to subsections 2 and 3 and section 6, the provisions of this act shall not apply after the death of either spouse, and every enactment and rule of law or equity shall continue to operate and apply in such case as if the act had not been enacted. Subsection 2. The death of either spouse shall not affect the validity or effect of anything done or suffered in pursuance of the provisions of this act. Subsection 3. If, while any proceedings under this act are pending, one of the spouses dies, the proceedings may be continued and be completed, and any appeal may be heard and determined, and the court may make such order as it thinks fit in the circumstances of the case, as if the spouse had not died. So I'm guessing there are certain circumstances in which the court made an order. The spouse died and the order is still in effect. Now, let's see section 4. Act to have effect in place of rules of common law and equity. The provisions of this act shall have effect in place of the rules and presumptions of the common law and of equity to the extent that they apply to transactions between spouses in respect of property, and in cases for which provisions are made by this act between spouses and each of them and third parties. Third parties, could those third parties be the bank, be other family members? It says the provisions of this act shall have effect in place of the rules and presumptions of the common law and of equity to the extent that they apply to transactions between spouses in respect of property. So remember, the property may be the family home, it may be bank account, it may be other property such as motor vehicles. So the provisions under this act shall have effect in place of the rules and presumption of the common law and of equity to the extent that they apply to transactions between spouses in respect of property. All right. And of course, third parties. Section 5, courts having jurisdiction. Subsection 1, subject to Section 11, in any proceedings relating to property instituted under this Act, the parties to the proceedings may apply A, where the value of the property in dispute is within the monetary limits prescribed by or under the Judicature Resident Magistrate Court Act, to the resident magistrate of the parish in which the property is located, or in which any of the parties reside, or as the case may be, to a judge of the family court. So if the value of the property in dispute by the spouses is less than a certain amount of money, then they can apply to the resident magistrate court or the family court, which is a lower court than the Supreme Court. All right. B, in any other case, that means it's more money than that, the value of the property is more than fall under the jurisdiction of the resident magistrate or the family court, they may apply to a judge of the Supreme Court in chambers. Subsection 2, a judge of the family court or resident magistrate may, upon the request of either party to proceedings upon an application referred to in subsection 1, hear such application in chambers. Part 2, family home.